Attorney Bill Berryman, who is helping us ethics members to make sure that we do everything correct. I would like to propose that Bill Berryman serve as counsel to us and that he provide legal advice in regarding the compliance of the ethics ordinance and process and procedures. I also request that he prepare drafts of the meeting minutes and procedures for review at the next meeting of the board. Okay, sorry. Can y'all hear me better now?
A little closer.
Okay, I'll get used to this. How about now? Is that better?
Yes.
Okay. My name is Tammy Hitchcock. We have Johnny Ellington and Lee Weems, and then Bill Berryman is his counsel to help the board, ethics board, throughout this procedure. I propose that Bill Berryman serve as counsel to the board and that he provide legal advice regarding compliance with the ethics ordinance and process and procedures. I also request that he prepare drafts of the meeting minutes and present them for review at the next meeting of the board. Can I ask for a motion to approve Berryman?
Motion to approve Berryman as counsel.
As complainant, I'm going to object to that. Essentially, the ordinance does not provide for an attorney or for the committee to be represented by an attorney. It only provides that the accused should be represented by an attorney. And the fact that Mr. Berryman is being paid for by the city is a conflict of interest.
Okay, it's duly noted, and since this is our first one, I wanted to make sure that we go by the rules of the ordinances. And so I felt it was in the best interest to have it. I don't want to do anything wrong. I mean, what you brought forth needs to be looked at, and that's why I requested us to have an attorney, just to make sure that we do everything correctly.
I understand the need for an attorney. I just think it's improper to have an attorney that's paid for by the city representing the committee that's meant to be independent. That would be a conflict of interest and would be a matter for certiorari in court.
Thank you for your objection. I recommend that we proceed.
Okay. Can second, so does that, since she made a motion, she can second.
Just go ahead and take a vote.
All in favor? Mr. Berryman is going to summarize the review of the process provided under the ethics ordinance.
Thank you. The ordinance requires that the board, after receiving a complaint, conduct a preliminary review to determine first whether or not a complaint is unjustified, frivolous, patently unfounded, or fails to state facts sufficient to invoke the disciplinary jurisdiction of the City Council. This review is based only on the materials contained in the complaint. The board may dismiss the complaint if it finds any of the above factors to be present, and those are factors that are in the ordinance. If the board finds that the complaint is not subject to dismissal for those reasons, then it is empowered to collect evidence and information concerning the complaint and to make findings and results of its investigation. The board is also authorized to conduct probable cause investigations, to take evidence, and to hold hearings. If a hearing is held, and I recommend that the complaining party and respondents be given the opportunity to request a hearing, a member of the governing authority, which in this case means the mayor and any council member who is subject of the inquiry, has the right to written notice of the allegations at least 10 business days before hearing, to be represented by counsel, to hear and examine the evidence and witnesses, and to present evidence and witnesses in opposition or in extenuation. Following a hearing, the board may request additional evidence or information to help the board with its review. After the hearing and gathering evidence, the board should consider the evidence and prepare written findings of its investigations and conclusions. These written findings and conclusions should then be forwarded to the City Council for review and action. It's important to note that this board, does not have any authority or ability to impose punishment or discipline. That is solely up to the city council. So the next step, I believe at this point, is to review the complaint that's been filed and to make a determination, again, on these factors, whether it is unjustified, frivolous, patently unfounded, or fails to state facts sufficient to invoke the disciplinary jurisdiction of the city council. And that is up to you to make that preliminary review.
So we're gonna review the complaint filed against Mayor Bridges and Councilwoman Ms. Betty Lyle by Catherine Corcoran.
On that matter, I have a couple of questions. I printed off a copy of the ethics ordinance from the city's webpage. And when you get up under the prohibited, actions, each item is designated using a letter as a bullet point. And in Ms. Corcoran's complaint, they were referred to as numbers. And I said, you got an ordinance that has numbers on them. I want to make sure that we're all on the same page. I think I understand what she's alleging. I want to make sure that we're all looking at the same individual subsections of the ordinance. So, Ms. Corcoran, may I ask you which copy of the ordinance you looked at? Would you verify that it was the same as what's on the webpage, just letters and numbers?
I do have one that has both numbers and letters. I don't know if we're looking at the same thing or not.
Okay. Would you mind if I brought you just to let you look at it for just a second?
Sure, I'll step up there.
That's fine. I'm happy with you coming through if you would want to do that. This is what I printed off of the city's webpage. Like the
No, so
prohibitions.
this is, I
Yeah.
guess, an older version.
Yeah, I see, she's got the same copy you do. I printed this off of the webpage, and I wanted to make sure, because like you refer to if you flip it, I want to hand there stuff. Like you got the numbers, like you violated, I'm just gonna say this example, number 7.
Right.
Okay, well, there's no number 7 on the ordinance. That's
Okay.
on the city webpage. I think I know what you're saying,
Okay.
but I want to make sure we're looking at the right thing.
Yeah, I mean, I guess you could refer back and forth to the copy that she has.
Okay.
Would
Is
be
this the
corresponding.
same?
It looks.
This the same copy that you used?
It appears to be.
Let's please make sure we're all looking at the same stuff, okay? Are you satisfied this is the same?
Yeah, it looks clear. It's the same.
Is that feel good?
That's a good
Okay, Ms. Johnson, do you have any comments about the complaint brought by Ms. Corcoran?
Excuse me, is this on the record? Yes. Then please speak up.
Oh, no comments yet.
Yes, I have a question on this under comment. My understanding of the ordinance was that it covers the receipt of something of a pecuniary gain by a member of the governing authority, which would be the mayor, city council, and people that they have appointed to boards. Is that correct? Is that what
That's correct.
Okay. Is there anything else covered under the ordinance? As far as, I know, receipt of pecuniary gain. In reading through it sometime, I thought I read something about an official directing city employees to do something, but I just wanted to make sure.
There is, in fact, and it also refers to appearance of not being equitable with citizens. So,
Well, and I'm looking at the one that's on the webpage. 1B, 2-107, 1B uses the directly or indirectly request, exact, receive, or agree to receive a gift instead of receive.
Is that the same language you're seeing, Ms. Wolf?
I'm sorry, what number you were?
He referred to 1B under 2107. It's 1B on the webpage.
I'm assuming it's in here, but I'm not seeing where we're looking, I'm sorry.
Directly or indirectly request, exact, receive, or agree to receive a gift, loan, favor, promise, or thing of value for himself or another person if it could reasonably be considered to influence the memory of the discharge official duties.
Yeah, I'm sure
That
that's
would be
in
2.5-103, number 2, on top of that you and I have.
Yeah.
That would be several different types of activity they're looking at. This would be the use of directly or indirectly is if it could reasonably be considered to influence the member in the discharge of official duties. And then the others are more direct. For example, use government property of any kind for other than officially approved activities.
It would help me if your agreements, if we could go through the complaint, the allegation line by line. You specify what you're alleging in the ordinance so that I can match it up with the number, the copy that you're both using.
Well, it may be helpful, basically I've listed in here ordinance 2.5, 102, number 7, 8, and 9. And then I said, but other violations are also alleged. So I took this to mean that the complaint only has to allege enough of a factual basis in order to be heard, but I have since gone back and enumerated the exact complaints with the numbers attached, and I can give that to you if that'll be helpful.
Okay, so in the,
And I don't have multiple copies, so I apologize.
so in the document that you filed, 102-789. So just read through those. I think
This is just ordinance 2.
and perhaps this is a question for another time. Why is the ordinance one way on the webpage and another way?
Are you looking for an answer?
It's back at that time.
Just because this is on the record, if somebody speaks, it would be helpful to state who it is that's speaking so that I have a name to go with. Yes, what I said, you can go on.
I'm a little befuddled by that. I spent a very bit of time reading through the ethics ordinances before this ever even arose and thought I had a pretty good handle on them, and then I get a copy of the complaint and I go look through the complaints, like this doesn't match what's on the webpage. And I've seen enough of Ms. Corcoran's communication to know that she's pretty well on point when she's making such things as far as the proper legal citations. And, we couldn't discuss this prior to it being in a public meeting. And so since I've gotten a copy of the complaint, I'm sorry, I look like an idiot sitting up here. I don't understand why that's the case. Why are there multiple copies in different formats rolling around?
That's frequent in a lot of the city's ordinances. In fact, if you go to the city's webpage right now and go under the Open Records link, you'll find a link there to the city's ordinance. And it has various like handwritten scribbling on it where it's been changed throughout the years. If you go to the police department page, you'll find another version of it. It seems to be pretty common.
Ms. Betty, do you have anything to add or that you want to provide in regards to this?
Are we having a hearing later after this?
Yeah, I just didn't know if you had anything.
I have nothing to add tonight.
Hey, Mayor Bridges, do you have anything that you want to add tonight? Mayor Bridges, do you have anything that you want to add tonight?
Not good.
So I think the decision before you now is to determine whether or not there's the complaint fails to rise to the standard that it doesn't basically state a complaint that you can adjudicate based on those factors that I read. That it's unjustified, frivolous, patently unfounded, or fails to state facts sufficient to invoke the disciplinary jurisdiction. It has to be pretty deficient before it would be subject to being dismissed, basically.
Mr. Chairman, I move that the complaint move forward. I believe it's been sufficient.
Second.
All in favor? Aye. Okay, so since this is our very first one, we've read through the complaint that was brought forth by Ms. Corcoran. We do feel that we need to look further into it. Ms. Betty, if you have anything that you want to provide, do so that we may look at that as well.
I'll do that.
And, Mr. Mayor, if you have anything that you want to provide, later.
Let me get up here so I can hear.
I'm sorry. I was trying to talk loud enough for you. I said if you have anything that you want to provide, later for us to review as well, then you feel free to do so, okay?
Go ahead, again.
I said, sorry. If you have anything that you want to provide, in regards to this, then go ahead and do that too for us later.
Yeah, I'll get what I need. What kind of information you looking for?
I guess anything on that, that's states why you agreed to pay for it out of the city budget. Anything that proves that.
Yeah, I'd like to provide the city sewer map, and explain, what we've done over the period of time. So, I think if you hadn't been here a while, you look at things a little different, way I have, I've been here a long time. So I just need to do some above on what y'all talking about, okay?
I understand from the reading of the ordinance, anyone that's been accused has to be provided a 10-day written notice before there's an actual evidentiary hearing, is that correct?
That's correct.
Has written notice been provided?
No, and what I have suggested and suggest is that tonight, this board adopt some rules of procedure, and then, once they've done that, then consider a date for a meeting, and then let the clerk get official notice out to the parties with a copy of the rules so that they can prepare for the hearing.
I'd like to object to that. Actually, there has been written notice provided several different times. I do have proof of that.
This board has not provided written notice.
Correct, but that's not what the ordinance says. It doesn't say that the board should provide written notice.
Thank you for your comments.
Well, you're incorrect, so we need to stick to what the ordinance says.
Thank you for your comments. Let's move forward.
So, we'll move forward with,
Y'all through with me? Okay.
we'll move forward with the, complaint, and we'll adopt procedures.
Would you like me to go over those?
Yes, please.
Okay, we've got a few copies here. I need, parties need to get copies, and then there's some more.
So, and for the record also, I'm going to object to this. At the time that the complaint was submitted, there is a completed ordinance. This is not a part of that. So it isn't proper to add things after something has been submitted. I would suggest that these be adopted for any future meetings or future complaints that the board may have. But generally speaking, I think Mr. Weems knows, as a law enforcement officer, you could not prosecute a person in court based on changes to the law that say occur after a person is issued a ticket. You would prosecute that person based on the law as it was written when that ticket was written.
One, this is an administrative hearing, not a criminal prosecution.
Correct.
So there's two different.
It's just an analogy.
From my reading of the ordinance, it gives the board the authority to adopt procedures. And the board has never adopted any procedures on how to handle a complaint.
I agree with that, but I would say that this board was instituted in 2018, and had the board wanted to institute procedures prior to a complaint being filed, that should have been done in 2018. So as we stand today, when I filed my complaint, there are very few procedures written in that ordinance. One of them has to do with submitting a complaint that is sworn to, which I did, within 6 months, and that is submitted to the mayor. So those are all things that I complied with. Adding additional things to it would be improper, and I think Mr. Berryman is contributing to this hearing in a deleterious way, in a way that's going to cause for the outcome, whether it favors me or favors Ms. Lyle. Not really favors me. I'm doing this on behalf of other people, so I don't really have a dog in the fight. However, I think that if you want for your conclusions to be recognized as ethical, then you would stick to the ordinance as it is written, and not add to nor subtract. And again, I think it is proper for you to put procedures into place, but they wouldn't be proper to be used for this particular
May I
hearing.
ask you how you suggest we proceed without adopting procedures?
Well, I mean, a very informal hearing would basically involve, as the ordinance is written, myself presenting evidence, which I've included some written evidence and included the people that I would like to ask to give testimony. So that would be a very formal, informal procedure. And then it also states that the subjects of the complaint can also present evidence and testimony. So very straightforward, just the presenting of the evidence that I have and a questioning of the witnesses for you to hear. And then it also states that you can subpoena witnesses that are additional to mine. I think there's been another understanding put forth by Thomas Mitchell that you all would choose which witnesses to hear. And the ordinance does not provide for that. And neither would a court of law either. I mean, both the plaintiff and defendant would choose which witnesses they each would like to present. And I have from the very beginning given a list of the witnesses that I believe are necessary to prove what I've offered.
From my own reading, I formed a list in my mind who I would want to talk to and ask questions of. But we have not had a chance to speak to each other as to how, I don't know who she wants to talk to, I don't know who Ms. Johnny wants to talk to, or hear evidence from. So I think as far as adopting the procedures, I think we're basically, we're setting how we're going to conduct the hearing, when that date's the evidentiary hearing, when that is set. You made an analogy to a criminal prosecution. There are lots and lots and lots of pretrial motions in which both the prosecutor and the defense argue back and forth over what the procedures are actually going to be for the trial, and then you get arguments over what the jury charge is going to be. So if we're going to use that analogy, I think this fits in with that analogy. I hear what you're saying. I don't see how we can proceed without saying, here's the rules of how we're going to do it. I don't see how we can.
All I would say is as long as they comply with the ordinance as written, I won't object to that. But if we get into excluding, for instance, witnesses or evidence that I have, then I would object to that. And it would also call into the question the conclusions that you arrive at in the end. Because bear in mind, the ordinance does say that the findings can be challenged by a certiorari. And I don't want to do that. That takes extra time for me, a lot of extra work and cost for the city. So
my reading on the challenge by the certiorari would be if say the city council were to recommend some person, the council, that person could appeal by certiorari to the Superior Court. I didn't read it as what the ethics board's finding was. Would you please refer me to which section you're looking at? And I don't want to get monopolizing.
So it's 2.5-112, right to appeal. And it says any final decision by the city council pursuant to the code of ethics for city council members shall be reviewable by Superior Court of Barrow County. Let's see.
Any final decision by the city council, not any final decision by the board of ethics.
Correct. There's somewhere earlier, and it may take me a moment to find it, but it also does say that essentially regardless of the decision made by the committee, it does not delete the right, it doesn't otherwise delete the right for the matter to be heard in court. And again, this is not something that I want to take to court. It truly isn't. It's something that I was asked to do, and that's why I'm here. And it's already taken more of my time than I would like for it to have, but I agreed to do it. And while you're talking, I can look for that. I'll look for that section, and I'll tell you when I found it, if you like.
Well, the board is in agreement that we do want to move forward with the hearing. We do find that there's enough here to move forward with it. So I hope you know, Ms. Corcoran, that we are looking at this very seriously.
I appreciate that, and I don't want